Okay, looks like we're just at the hour here, so let's get started. We've got an awful lot to cover today. My name is Joseph Caniglio, and I am the Director of Antitrust and Innovation Policy, as well as the Schumpeter Project on Competition Policy here at the Information Technology and Innovation Foundation. On behalf of ITIF, I want to welcome you all to this very special panel, Whither the Limits of Antitrust, Assessing the US v. Apple, DOJ v. Apple case. So by way of a brief background, just over a month ago, the DOJ filed a much anticipated antitrust lawsuit against Apple, claiming that the company monopolized both the smartphone and performance smartphone markets through a variety of alleged practices that include restricting platform access for third-party super apps, cloud streaming apps, digital wallets, as well as limiting messaging interoperability with rival mobile platforms, Android, and tying the use of its smartwatch to its iPhone. So to discuss the case, I'm honored to have with me a very, very distinguished panel of experts who really need no introduction. So I'm going to take the liberty of being brief and we can jump right into the substance. So first, Alden Abbott, Senior Research Fellow at the Mercatus Center at George Mason University School of Law, where he was also an adjunct professor of law for many years. Alden has had a distinguished career in government from 2018 to 2021, serving as general counsel of the Federal Trade Commission, where he had previously worked in a number of senior roles in prior administrations. Also spent many years at the Department of Commerce, including as acting general counsel, and additionally as special counsel at the Antitrust Division during the Reagan and Bush 1 administrations. He's also held high-level roles at BlackBerry and the Heritage Foundation. Very good to see you, Alden.
Thank you.
Second, Rebecca Hall Allensworth, the Associate Dean for Research and David Daniels Allen Distinguished Chair of Law at Vanderbilt University School of Law. Rebecca teaches and publishes widely in antitrust and is also the recipient of the Jerry S. Cohen Memorial Fund Writing Award for Antitrust Scholarship. She's presently working on a book on professional licensing and self-regulation, which I'm happy to plug for her here. Prior to academe, Rebecca served as a law clerk to Judge Richard Posner in the Seventh Circuit, and then was also a Klemenko Fellow at Harvard Law School. Very pleased to have you with us, Rebecca. Thank you. Third, Keith Heilton, the William Fairfield Warren Distinguished Professor of Law and Professor of Law at Boston University School of Law, where he teaches and writes broadly in antitrust, law and economics, torts, IP, civil procedure, economic analysis, probably missing a few there too. He's published 5 books and over 100 articles. And among his many distinctions was previously president of the American Law and Economics Association. Keith has kept the tradition alive of public intellectual. He's frequently quoted on antitrust and many issues of the day. So very, very glad to have you with us, Keith.
Thank you.
Finally, Doug Melliman, scholar in residence at the USC Gould School of Law and visiting fellow at Stanford Law School, where he was previously professor of practice and then scholar in residence. Prior to joining Stanford, Doug was senior vice president and general counsel of Intel, and before that, longtime partner at WilmerHale here in DC, where he was chair of the firm's antitrust and competition practice. During the Clinton administration, Doug served as the Antitrust Division's acting attorney general, and then prior to that, principal deputy assistant attorney general. Doug is also widely published, I think it's fair to say, really been one of the luminaries in antitrust law and economics over past decades. Very much appreciate your time today, Doug. So welcome to all of our panelists. And with that, why don't we just jump right into it? So Keith, I'm hoping you can lead off for us here and get us going with the threshold question of whether Apple is a monopolist. I know you've said publicly casting doubt on the notion, so perhaps we can begin with how the DOJ is just defining its relevant markets here, this performance smartphone market. Are these well defined by antitrust standards? What are your general views on that and the monopoly power issue?
Well, I should start off by saying that I personally don't put a lot of weight on the market definition and market power questions because they are so indefinite and elastic, and a lot depends on how you interpret. And there's this sort of indefinite edge to every market definition where you could expand it or contract it, and it wouldn't make a difference really. And I think one of the most important points that come out of the theory in this area is that the important things to think about are market share, demand side substitution, and supply side substitution. If you're doing those things correctly, then the market definition is not that important to get right, which is kind of surprising to think of, but that's really true. But let's go back. Let's look at this case. In this case, the DOJ has said, well, there are two relevant markets. One is the performance smartphone market, which I guess consists of Apple and I don't know who else is in there. But Apple is a large share of the performance smartphone market and the general smartphone market. And the general worldwide smartphone market, I think Apple's market share is, I think, fairly low. I don't remember the number, but it's got to be way less than 50%. And Apple, I think, is in the process of being pushed out of the China market too. So its market share globally is probably going to go down, if anything, over the next couple of months. In the performance market, which is much narrower, I think its market share is maybe 65-70% or something of that level. So in terms of the traditional measures of monopoly power that courts have looked at, these numbers are low, even in the DOJ's best measures. On the other hand, as I started off saying, I'm reluctant to put a lot of weight on the numbers alone, because when you're trying to really measure market power, you're looking at a lot of different variables, at least three, and not just market share. So that said, I think the numbers certainly aren't strong on the part of the DOJ side. On the other hand, I don't put a lot of weight on those measurements myself.
Thanks, Keith. Alden, I want to make sure you get a chance to weigh in on the market power issue and also the geographic market question. Obviously the DOJ has defined a national market here, but Keith's already mentioned the international dynamics. What do you make of it?
Right. Well, it's interesting. I think globally, Apple, the iPhone only has a 20 to 30% market share of that. And that in most countries, there's larger revenue and more accruing to Samsung, and much larger share in terms of actual unit phones sold than Apple. So, of course, you could say, well, U.S. consumers are not buying phones overseas; they're buying them here. That's fine, but even here, if you look at the total number of handsets sold, there you could argue that it's fairly equal. It's where Apple prices its phone higher, gets higher revenue, but it's highly differentiated industry. I think Apple would argue, look, it shows greater consumer demand for a product. Others can innovate, and we're limited by that potential innovation. You have not just Samsung, but a number of other smartphone producers, basically open platform, and there's lots always new cameras and heavily advertised. If one goes on television, or their supposed improved features these relative to Apple are being emphasized, and they cost a lot less than Apple phones. So to me, it's a little harder in the traditional sense to say Apple is a monopolist. In contrast, say, to Microsoft, its Windows operating system 25 years ago, it was very hard to say it was not a monopolist in the U.S. operating system market. I think it's not really comparable to the situation you have in the smartphone market.
Thanks, Alden. No, I think that's a good way to sort of take it forward on the market share question, because obviously that's not the only determinant factor, but a key one for monopoly power. And obviously, at Microsoft, we had numbers well in excess of 90%. Rebecca, maybe turning to you, how do you see the monopoly power question, and maybe especially on this market share issue, and also how the DOJ is calculating market shares, and whether or not there may be some questions on that, especially when it comes to how we value Android, given some of the commercial relationships in that area.
Yeah, so I'm with Keith. I'd rather not define markets if we didn't have to, but unfortunately, the law is such that you don't have Supreme Court precedent saying you have to define a market, but you almost do. I tell my students it's malpractice to go into to write a complaint without defining a market for a monopolization claim. But I think, as Keith points out, the real question is not market power, and in some way, I mean, it's not market share or defining the market. And so in some ways, we're sort of making that mistake by starting the panel with what is Apple's market share. The real question is, do they have monopoly power? Monopoly power is the power to raise prices or change quality for the worse profitably, and the power to exclude. And so you can't really answer those questions, or indeed market definition, without understanding the theory of harm. And this is where I think invoking the international shares doesn't make any sense to me, because the question is, what can Apple do in the US to keep the quality of its phones low, to keep consumers from switching away? And the answer to that question is whatever it thinks it can do, and consumers won't switch. So what choices do consumers have when they switch? They have, 35% choose a different product. That is a significant ability to switch, as Keith points out. I think a plaintiff would feel much more comfortable going into a complaint like this with something closer to 100%. But that is the relevant question. It's not 25, 30%, whatever the international question is. And then I also think that when we're thinking about monopoly power, there's this push and pull between market definition and then monopoly power. So you can do what you did in Microsoft and say the market excludes all other kinds of operating systems other than Windows, and suddenly you have 100% market share, and then you're good to go on the monopolization question. So you win on the market definition question, then you don't have to fight on the power. Of course, Epic tried to do that in the last high-profile Apple case, and they lost. And so this, I think, reflects a new strategy, which is, okay, we're not going to fight as hard on market definition, but we're going to have a fight about power. And I think, as Keith points out, like 65% is not great for the plaintiff. However, there's plenty of precedent saying that that's enough for monopoly power. There's plenty of precedent in the Third Circuit saying that. The question is going to be ultimately about power. Can they raise price, lower the quality of their products, and not worry about consumers switching away? And I think that the complaint says that. I mean, it's a complaint. They haven't proved anything yet. Apple hasn't had a chance to respond. But to me, the complaint says that.
Thanks, Rebecca. Well, market shares are usually something we hear a lot about from the folks currently running the agencies, but perhaps they'll take a different approach. Doug, turning to you, and I think maybe getting into some more of the real forces in the markets that Rebecca is hinting at as to how to identify power. Obviously, barriers to entry is a key one, and we hear a lot in the complaint about Apple as a platform. So what do the law and economics there tell us about how the market definition question or power question might be resolved? How does the platform angle factor in?
Well, let me first say I completely agree with Keith and Rebecca that market definition shouldn't be the controlling issue in this case. It's a question of power. It's a question of whether Apple has the freedom from competitive constraint that it would need in order to take actions contrary to the interests of their customers or the app developers to profit from doing that kind of thing. And that's going to turn on the market facts, it seems to me, more than on the formalities of what is the market or the nomenclature, the label of whether Apple is a platform or a product. I don't think we should get hung up on that nomenclature. The issue is with whom does Apple compete and what are the competitive constraints when it sells phones to users or app distribution to app developers. And the issues might not be, of course, the same for both groups. Now, as a kind of factual and economic matter, I think it's clear that smartphones are platforms, especially when they permit third-party apps to have access to the distribution network, because the iPhones connect third-party app developers with users. Now, the complaint alleges that the phone is the product, and that's true whether you call the phone a device or a platform. It's not a transaction platform in the sense that the Supreme Court defined that term in the Ohio versus American Express case. So I think there shouldn't be any serious question of whether the plaintiff has to prove a single two-sided market dealing with Apple, and so this case shouldn't be governed by some of the loose and, in my view, flawed language in American Express about that issue. But the question is going to be a simple factual one. What are the competitive constraints on Apple? And there, one thing I would want to add to the discussion so far is that I think more can be made from the plaintiff's point of view of an aftermarket, a kind of a lock-in of the installed base. I think a lot of the discussion of switching costs is clearly about that. And the complaint in a number of places says the real issue here is the sale of phones to people who already have an iPhone. What are their options? And the case, Rebecca referred to the importance of looking at the theory of harm. The case in large part turns upon allegations that Apple engaged in conduct to make it harder for people who already own an iPhone to be in a position to switch to non-iPhone products, in other words, to look at alternatives to the iPhone than would otherwise be the case. And so I think the theory of harm and the idea of market power or monopoly power over the installed base dovetail nicely, and that might well wind up being the focus of the market power question.
Right. Well, let's get into the conduct then, because obviously not just is exclusionary conduct evidence of potential market power, but it's what you need to make out a Section 2 case. So, and Doug, why don't we stick with you and sort of go through with the DOJ's allegations, maybe sort of one by one, starting with this super apps allegation. And, they invoke the term middleware, which obviously gets at a case I know you know well, US v. Microsoft. And I think something you mentioned is potentially a relevant precedent here. And also, of course, something the DOJ's case actually discusses at length, sort of as background, which probably another issue entirely we probably don't have time to get in with. But keeping it sort of on the merits here, and we'll get to the switching costs point later, but how relevant do you think Microsoft is going to be, both with the super apps claim, also more generally, and then how do cases maybe like Trinco also factor in to the arguments?
Well, I think both of those cases are going to be mentioned a lot in the briefs, but they raise really two very separate issues, I think. The middleware story is about the mechanism of harm to competition. The middleware analogy is clearly correct conceptually with respect to super apps and cloud streaming, which threaten to transfer value from the phone to the cloud and thus diminish the value of the Apple phone or the Apple platform, call it what you will, both absolutely, in other words, it's not any longer essential for certain kinds of functionality, and relative to competing phones. And undermining middleware like that can harm competition, both by commoditizing the platform or the phone itself and reducing Apple's market power, and by providing or by undermining the availability of complements to new or strengthened rivals in the platform market. So I think the middleware story and the analogy to Microsoft in that respect is very sound. Now, Trinco has nothing to do with that. It goes to the separate question of whether the conduct alleged to undermine the middleware was anti-competitive for antitrust purposes. Apple will surely rely heavily on Trinco in its defense, and there are those who read Trinco sufficiently broadly to call much of the complaint into question. The argument's going to be, of course, we can choose with whom we want to deal, what apps we want to have on our platform. We can set ground rules for permissible and impermissible apps, and that's all we're doing. I don't think, personally, that Trinco read properly is a bar to the middleware claims, assuming the facts as alleged in the complaint. So for a few reasons. First, Apple chose to deal with third-party apps, and now Apple is applying its policies, according to the complaint, selectively to preserve its monopoly. And Apple's refusal to deal, and this I think is a really important allegation that comes up a few times in the complaint, Apple's refusal to deal with the middleware, the middleware that allegedly jeopardizes monopoly power, involves a profit sacrifice. I think if the plaintiffs can prove all three of those points, that then leaving possible affirmative justifications aside, which I think is where this case is going to be decided, but leaving that aside for now, this case may wind up being a lot closer to Lorraine Journal than to Trinco.
Thanks, Doug. There's a lot I think we're going to get into there, but why don't we start with the cloud streaming app point that you raised, which is also sort of the next major allegation the DOJ has. And turning to Keith on that one, Doug also mentioned the switching cost argument, which is something I think we see in the complaint a lot, and really is, I think, something the DOJ relies on, a key mechanism of how they're conceiving of exclusionary harm. So what do you make of both the cloud streaming app claim and then also maybe more generally the switching cost argument?
So let's see, I don't know where to begin with this. The cloud streaming app, I mean, there are other claims of a similar nature, such as the claim about super apps, these apps that allow you to do all sorts of things on the platform within one app. And the theory behind that complaint is that Apple is willing to put itself at a severe competitive disadvantage by excluding these apps, which I guess I'm a little suspicious of to begin with, to think that Apple would put itself, would deliberately hamper its own ability to make its product attractive to consumers by excluding these apps, which are apparently valuable, solely for the purpose of, maintaining its power in this market. That seems a bit implausible because Apple is under pressure to compete and prevent its customer base from switching over to Android. So I start off with a high degree of skepticism about that charge. As for switching costs, in theory, yes, switching costs can give a firm with a dominant position, this ability to lock in these aftermarket consumers. But there are limits to that. Switching costs are not infinite. Switching costs are finite, and certainly a company can push its luck too much, and the switching costs no longer hold people back, because again, the switching cost is how much does it cost me to switch over, and what's the benefit from switching over. So there are two components of that. There's a benefit from switching and a cost from switching. And if the company pushes its luck too far, the benefit from switching will exceed the cost of switching, and consumers will switch. So I think that's a constraint that's always there on Apple. We're into empirical questions about how important the constraint is. The DOJ will have to prove that it's an important constraint. I start from a position of skepticism. I don't think the switching cost is an important complaint relative to the benefit, if we're talking about very serious beneficial applications that Apple is denying its customers access to. And I would think that some of these apps, I don't know what Apple's justification is because I don't know the details that deep. But take the case of WeChat, the super app from China. I think Apple probably has all sorts of security issues for not making that app available to consumers. I want to say one thing about Trinco. I think Doug raises very good points about Trinco. I think the question is, how do you read Trinco? And it's not clear how you read Trinco. You can read it broadly or narrowly. The Supreme Court, in a case called Linkline, read Trinco in what I would describe as almost a ridiculously broad fashion, and so that leaves the courts kind of having to figure out how to read Trinco. But I would read Trinco maybe not as narrowly as Doug is reading it. I would read it broader than Doug is reading it. And I would say that Trinco pretty much stands for the proposition that if a firm is going to refuse to deal with a rival firm or competitor, then the evidence has to show that there was one sole reason for it, and that was to destroy competition, to destroy a competitor. That's it. If there are other reasons, if there are other justifications, even if the firm is just trying to protect itself for some reason, in some way, then the Trinco, then your Trinco basically protects that decision to refuse to deal in the part of the dominant firm. I think that's the sense in which I would read Trinco. Maybe I'll stop there.
Yeah, no, that's helpful. We're going to get into the pro-competitive justifications hopefully later on if we have time. But Alden, I want to turn to you because obviously, in addition to foreclosure or some kind of harm to rivals or competitors, to make out a cognizable antitrust claim, you need to have harm to consumers. And we'd love to get your thoughts on that, generally with respect to the DOJ's claims, but also perhaps in particular to this third allegation regarding the messaging, green bubble, which I think is already infamous among some of the commentariat, and whether social pressure or social stigma can really be a antitrust harm. In the words of one commentator, very popular these days, maybe our haters just going to hate. How do you take it?
Well, let's just start out. To me, it seems dubious to use social pressure. It's hard to measure, quantify it as a cognizable harm. And as to the green bubble, what's behind all of this? Note that Apple has explained. Look, Apple has its own iMessaging service, which involves strong encryption and strong safety measures, and it certainly interconnects. You can certainly read the messages, albeit in the green bubble. It has a blue bubble, by the way. Is green worse than blue? I don't know, but they would argue that, look, we're not turning over our APIs because this SMS is not encrypted. SMS is used for a lot of messaging. And they say, look, we of course will allow messaging to non-iPhones, but we are not going to get into the game turning over our APIs. We have no duty, no duty to do that under Section 2 law, they would argue. And we think we have a very safe system. We want to protect that, and we think our consumers recognize that. And so again, we want to hold on to our APIs to protect user security and privacy. If it's not protected, consumer welfare will go down, demand for a product will go down, or its reputation will go down. So all we're doing is protecting our product from reputational harm. At least that's the argument I would expect they will make.
Thank you, Alden. I think that's really getting at something we're going to talk in more detail later on about exactly the legal standards here. But Rebecca, I want to turn to you also on some of the theories of harm that the DOJ is raising. And we've heard Microsoft be discussed. That implicates predatory design. One way to look at this case. We've heard Trinco, refusal to deal angle. There's also the tying angle, especially with respect to that smartwatch claim. So maybe you could touch on that and tell us how you're seeing these claims.
Yeah. So I mean, like Microsoft, it just depends on your perspective or your model, maybe, for what's happening here. Is this a refusal to deal case? Is this a tying case? I think the Third Circuit precedent in particular, but in general, our federal antitrust precedent is not obsessed with these boxes in the way that Apple is hoping. I think that they're going to look at the underlying conduct and they're going to ask questions likely about sacrifice. At bottom, the point of a Section 2 case is, are you sacrificing short-term profits in pursuit of market share and market power? I don't agree with Keith that the question is it the sole reason why you're doing what you're doing? I don't think that that courts have endorsed that. The Supreme Court has not endorsed that. No one has endorsed the no economic sense. But it is a high bar, according to Trinco. Trinco doesn't say that you have to only be intending to exclude. And it's also not firm or fixed. I think another thing that's important to see is as Doug said, the way you read Trinco, the way you read these cases differs on your perspective and on what you think is the harm of monopoly. And that may be different 20 years on from what it was then. And I think that that's entirely appropriate and has happened before in the history of antitrust as a common law. So anyway, that's a little bit of a more rambling answer than precisely on the tying. Is it a tie? Yes, it's a tie. It's possible that the court could see it as a tie in the same way that they saw Microsoft tying its operating system to the browser. But again, whether we're doing, Jefferson Parish, whether we're doing Kodak, as your model for the tie, the question is going to be sacrifice. Are you making these choices primarily for the benefit of your consumers or for your own market share? And that's why we have such a hard time staying away from pro-competitive justifications. I know you want to leave that for a later part in the panel, but that's why we're all so interested, because that's really the question, is how well will they be able to prove those things?
No, I think it's perfectly fine that we get into that. And I would just remind our audience, if you have questions, please do submit them vis-a-vis the Slido link. And let's just move to that then. So Alden, why don't you start us off? You've already noted some of the justifications that were made here, but maybe describe them in a bit more detail. And also, I mean, how likely do you think they are to convince the court?
Well, I think it's key to see, and we'll see how it's going to play out in court. But Apple has already said we've addressed several of the DOJ concerns, and when indeed they argue they've refuted some claims, already made initial complaint. And for instance, they argue that Apple argues DOJ's portrayal of contracts and commissions is misleading. That company says over 85% of developers don't pay commissions. Vast majority are eligible for a reduced 15% commission rate. This 30% supposed charge or tax rate is actually charged. Similar charges are found on Google, related phones and other platforms. But regarding super apps, they claim it's they say we've always allowed super apps to exist on iOS, such as Facebook, WeChat, and Line. They'll argue that cloud streaming services say cloud streaming has always been allowed on the App Store, and the company has even modified its guidelines to promote such services. And as to cross-platform messaging apps, again, I already mentioned that, but I think they've argued there's no data suggesting users desire SMS functionality in third-party apps. And note that WhatsApp and Signal do not offer SMS on Android. So again, so that's one of their points. As to smartwatch functionality, is that exclusionary behavior? They've argued that to make the Apple it compatible, Apple system with third-party watches would require accounting for every model, operating system, and more, which is technically infeasible or ridiculously expensive. We'll see if that proves true or not. But they also claim that fitness bands and smartwatches and certain apps do work with iPhones, and access is given to APIs. Now, the wallet. Apple says we're using NFC, secure element, special technologies to promote ease of entry, safety, and security for customers. That's part of the demand for our product. And there's also their competitive advantages do not prevent users from switching to Android. And by the way, I think they haven't, but they point out there all the time. One sees these promotions by a variety of by AT&T and others saying that we can give you an iPhone on a new Android at a very low price. It's easy to transfer data from an iPhone to an Android device. They'll claim that cuts against the idea of the switching barrier, and it's the size of the switching barrier. And so I think again, all of these things will have to be analyzed before the court. But I think the bottom line is we're just going to have to see factually. And basically, I think the picture is, look, a lot of things DOJ is complaining about are really aimed at protecting the integrity of our system. We don't go beyond what's necessary, but that creates value for our customers in the security. And if you start fooling with that or requiring us to have all sorts of additional compatibilities. It's very costly. It may raise security concerns, and it's really interfering with particular aspects of our system that allow us to charge a premium price because of consumer demand for it.
Thanks, Alden. Rebecca, I want to get your thoughts on the pro-competitive justification issue. And, I'm not sure we're entirely in the dark. Obviously, I think it's already been mentioned, we have the Apple v. Epic case that's out there. And, there was some guidance there, at least on those facts. The court thought that Apple's privacy and security justifications were strong. So do we think that can tell us anything here?
I think it's a data point, but I don't think it's entirely predictive. I mean, this is going to be, as Alden says, very fact intensive. And it's going to be specific to these things that Apple is supposedly have done. So I don't think it's enough to wave the banner of privacy and security vaguely and win this case, nor can you say, well, it worked in this other case, and so it works here. That case was about similar but different conduct about the store. This alleges different ways in which Apple is using its monopoly power to maintain it. So it's a data point. It's how one court perceived factually the less restrictive alternative arguments and the pro-competitive justifications. And then that, of course, got reviewed deferentially by the Ninth Circuit. So, yes and no. I think it's entirely appropriate to put the burden at this point on Apple to say and defend its decisions as providing value to consumers. I don't think it's at all, been litigated, been there, done that. I think that we'll see, as everybody keeps saying, we'll see. They have their day in court.
Well, I think it's fair to say one of the differences between the Apple Epic case and the DOJ's case is the Section 1 rule of reason that was really at issue there versus here we're in Section 2 land. And, Doug, I want to turn this one over to you. Might it actually be easier for Apple to make out pro-competitive justifications under Section 2 relative to Section 1 vis-a-vis, maybe not having to show or having to show a least restrictive alternative? Maybe there's a reasonable necessary condition that would apply between whether the conduct is necessary to get the pro-competitive justifications. And even if we're looking at Microsoft, did Microsoft even have that sort of additional requirement that Apple would need to satisfy to make out its pro-competitive justifications? How do you see it? And not to go back to Trinco, but of course we have that language in there about not having carte blanche to insist that a monopolist alter its way of doing business whenever some other approach might yield greater competition. What do you think on that question?
Well, I don't think the issue is whether competitors have carte blanche to require Apple to do anything. As to less restrictive alternatives, I want to talk about them a little bit in the context, but I don't see a lot of difference between Section 1 and Section 2. Apple's not going to have to show that it has used the least restrictive alternative, but if it shows substantial justification, then the plaintiffs will have the burden of coming forward and saying, wait a minute, they could have gotten almost the same benefits with some alternative that was a less restrictive of competition. But the burden for that, I think, is going to be on the plaintiffs, not on Apple, at least in the first instance. But let's take a look at these justifications. There are two of them, as I understand, that are going to be the core here. One, security and privacy. We've talked about that. And clearly, Apple's going to say our whole brand, our whole reputation is built on security and privacy. The complaint alleges a lot of ways in which the particular conduct the government complains of is actually undermine security of the particular product, but Apple will say, but overall that promoted a more secure system. And that's going to be a serious issue for them. But I think there's an aspect of this that was glossed over by the Apple case that needs to be addressed here, and that is that it's one thing for Apple to say, I'm in the business of making Cadillacs, not Chevrolets. It's quite another for it to say, when it opens up its platform to third-party apps, well, I'm going to make sure that all the third parties are making Cadillacs and not Chevrolets. I think what they have to demonstrate is not that they are just carrying out a vision, but rather that they're protecting a legitimate interest of their users from third-party apps that don't meet their standards for security or privacy. Now, those interests could be one of two things. It could be that if there's a breach of a third-party app, it also breaches the phone or other apps on the phone. There's an externality of that sort, and that they're really trying to protect the phone from being invaded that way. The alternative, which I think Alden may have referred to earlier, would be to say that their brand is undermined because they'll be blamed if there's a security problem because of a third-party app on their phone, even though it wasn't their fault. And as to that, they're going to face a least restrictive alternative argument. Well, why can't you we all get these pop-ups, right? When we use our browsers, it says this site isn't safe or whatever it is. They can have a pop-up and say, well, this app doesn't meet our security standards. It's not safe. Ironically, the green bubble could show a path toward a less restrictive alternative because it's a way of saying to the user, oh, you're getting into an area where there's less encryption. And the question will be, can Apple protect its legitimate interest by those kinds of alternatives? The other justification that I expect Apple to use, and we haven't talked about much, I happen to think it's a legitimate one, I know others don't, is that they're entitled to compensation. They're entitled to the monopoly fruits of their legitimate gains in building this very attractive iPhone ecosystem. And they're going to say, well, we've monetized it by our 30% charge for devices and 30% on in-app purchases. And if some of these, like the cloud streaming and all, are ways of circumventing that tariff collection, as it were, then we're not getting the rewards for our lawful monopoly to which we're entitled. And the question will become, well, aren't there other ways that you could get substantially the same compensation? So I think that's how those less restrictive alternatives are going to come into the picture, but it's not going to be that they have to prove that theirs was the least restrictive. I think the plaintiffs will have to show that whatever legitimate justification Apple proves could be substantially served by an alternative less damaging to competition.
Right. So Keith, I want to go to you now, and obviously, assuming that we have this least restrictive alternative, or even if not, assuming Apple can prove some pro-competitive justifications that hold up, we also have this idea of balancing that could factor into a rule of reason type of analysis, and would be curious to get your thoughts both on the justification, but in particular, if there is some sort of balancing, how might that play out, especially. I think maybe is this a soft spot, considering maybe there's some issues about cross-market efficiency effects, which I know something also raised in the Google search case. And then even some of the ideas that, these justifications along the lines of privacy and security. Now, in the Epic case, the court obviously found that they were legitimate. I think there were some arguments maybe suggesting they were non-economic, but they're legitimate. But still, maybe a difficult balancing analysis here. How do you see it playing out?
The balancing question is obviously a difficult one, because how can you balance apples against oranges? If you look at the Microsoft case, I don't think there are any real examples of balancing. It's in fact, in the cases where Microsoft, the defenses where Microsoft wins, it's because it offers a pro-competitive justification, and the DOJ didn't have any rebuttal, didn't have any basis for showing that pro-competitive justification was just pretextual or fake or anything like that. And where Microsoft has a good pro-competitive justification, it prevails in the Microsoft case. Where it has a lousy pro-competitive justification or no pro-competitive justification at all, it loses in the Microsoft case. So presumably the same sort of thing would probably play out in this case. I mean, maybe the balancing that's really going on, suggested by the Microsoft case, is burden of proof balancing. Just saying, okay, you really have the burden on this one, and you didn't make it. You didn't meet the burden. And so hopefully Apple would be able to learn its lesson by looking at the Microsoft case and figure out where it has to offer something and how much it has to offer. But it doesn't seem that we have real examples of actual balancing, because that's so difficult to do. And I would say that the Microsoft case would appear to offer a pretty clear roadmap to Apple about how to deal with this defense. Another question I want to raise, though, is, there's an issue about what's the end goal of this? What's the remedy? Take, for example, suppose the DOJ said, well, we're going to ask you to get rid of that 30% tax in the App Store. Just get rid of it, or, lower it to 5%, whatever. What happens as a result of that? Does Apple realize, well, in order to make the profit that we need to make, we have to raise the price of the iPhone instead? So we lower the tax in the aftermarket, but we raise the price of the iPhone. Is that good for consumers? I'm not sure that I see a remedy that's good for consumers coming out of this, if it's something so simple as lower the tax in the App Store, because you could argue that the App Store tax is actually a pretty nice pretty nice method of price differentiation, which is efficient and expands the market for iPhones and iPhone services.
Thanks, Keith. And I think that's we got 15 minutes left here. Good place for sort of jump in maybe to some of the bigger picture, broader implications of the case. Rebecca, why don't I start this one off with you? So you had a piece in the LA Times on this case, which again I commend to our readers. And you talked about how there were some unique elements here. And I think one of the questions I've asked about these cases before is this a standard antitrust case that we might find in the consumer welfare standard, or is this the elusive unicorn where we finally get to see the neo-Brandeisian theories really in action? How do you see this case within those broader debates?
I see this as squarely a consumer welfare case. I think that what the neo-Brandeisians have brought, I think the neo-Brandeisian ideas, as translated to actual actionable cases that they've brought in court, and by the way, their merger guidelines, are the consumer welfare standard with a different timeline on consumer harm and a different attitude towards certainty and who has to be certain about what's going to happen to win the case. And to me, that's still very much about consumer harm. So, without saying anything about what the neo-Brandeisians say in the media and they say in their scholarship, what I can say is that what they say in their lawsuits, if we attribute the actions of the DOJ and the FTC to the neo-Brandeisians, which I guess we can because they're run by, people in those camps. I think what we're seeing is still very focused on consumer harm. It's just asking more realistic questions about how consumer harm happens, when it happens, and changing the burdens of, how certain do we need to be that it's going to happen. That's the way that I view the neo-Brandeisian regulatory actions, as opposed to the neo-Brandeisian ideas as espoused in the media and in articles.
Alden, I want to get your thoughts next on the big picture issues here. Obviously, respond to Rebecca, but also, I think you mentioned too kind of how Apple sees this case really as an attack on their business model, and maybe neo-Brandeisians like to focus on the political context, democracy, but maybe looking sort of at the geopolitics and the international landscape. Obviously, we have the EU and the DMA basically telling companies they need to open up their platforms. Is this how is that sort of international context, and also we've already mentioned with respect to China and the growth of its products? How does that factor into this case?
Well, certainly, I think it can be credibly argued that, look, the ability. It was a book that came out from a former colleague of mine on that basically on freedom, that if there's no showing of general market failure, you want internet as an example of regulatory freedom. For a long time, there was no talk. Certainly, the Clinton administration decided not to talk or think about regulating the development of the internet, and it allowed the development of these very successful platforms, which did not happen in Europe, which has sort of a more precautionary principle approach. China, which has very rapid technological advancements. Apple could argue, of course, it hasn't gotten heavily into AI, but says, look, we are very profitable, but it's not because DOJ claims we've degraded the product. To the contrary, we get huge numbers of additional apps every year. If you look at the record in recent years, they keep growing, 30% tax or not. Our other smartphones keep offering these huge deals to consumers. Is that the sign that that would seem to be some sign, arguably, that Apple's preference for Apple remains strong and perhaps stronger? And again, you're talking about in an imagined alternative world, somehow there would be a superior product. Well, the real superiority really seems to be tied into Justice's claims that there was required sharing or required dealing with rivals. But again, Apple is saying that's precisely why we're superior. We've been able to develop our platform in our own way. And look, there are lots of different variations from our competitors, and they haven't up to now developed their own platforms. This is inter-platform competition. And so I think that would be a point that they would make. And it's heterogeneous taste, consumer. It's hard to believe they would say that consumer demand continues to grow, and a number of apps continues to grow, and people are clamoring to be able to get into our app store. That I think the app argument is it's really a fight over the distribution of rents. Apple says we need these rents to keep improving our product. You could argue that people say, well, we want the advantage of being in the Apple store, and we don't want to have to pay what Apple is asking. But that's just a distribution of rents argument. And Apple could say, look, they're trying to free ride on our reputation without having to pay for it. Anyway, just some of the arguments I expect, and particularly in a time of competition with China, I think you don't want to do anything that creates disincentives for our leading platforms to innovate as they see fit.
Keith, I want to make sure you can weigh in too on the big picture issues. And Rebecca talked about some of the other cases that are going on as well. Obviously, Apple's not the only one, and we have seen some discussion that the Academy, the commentariat, sort of ranking the merits of the various cases, Google cases, Meta, Amazon. How do you maybe see this in the context of those other actions, and maybe just simply which one is the DOJ most likely to win on?
I don't have a guess on which one the DOJ is most likely to win on. I mean, this in the end, I guess with all of these cases, you have to wait and see what comes out and what their evidence is. Even with this case, you have to wait and see what their evidence is, and what Apple has to respond. I start from a position of skepticism, and I view this case as a weak case, but that's based on Apple's historical strategy in the market, which has been largely to cultivate the high end of its markets, whether we're talking about PCs or whatever electronic device we're talking about, cultivate the high end and cede market share to other businesses like Microsoft or Android. So I start from a position of skepticism, thinking this is a tough case for the DOJ to prove. And for that reason, I'm inclined to rank it pretty low among these four cases that are out there right now. But, in the end, I guess I've been around long enough to say, let's wait and see. Wait and see what they have to say. As far as the bigger picture that you touched on, yeah, there is a bigger picture issue given competition in the tech area, given investments in AI, given that Apple is one of our dominant tech firms and is making huge investments in all of these areas. We know that Apple is under enormous pressure from China. I mean, they're basically trying to push Apple out of that market, which has been a major source of Apple's profits. The lawsuit itself is going to cost Apple, and the market valuation of this lawsuit is about 100 billion, I think, on Apple. Yeah, I mean, I think we do need to think carefully, because if we attack these businesses, once the DOJ attacks, the other international competition agencies follow in its train and just ramp up the attacks. That was the history with the Microsoft case. So we are taking a risk with innovation in the US when these lawsuits are launched by the DOJ. And the DOJ should be taking those issues into account when they decide to launch these cases.
Doug, I want to get your thoughts on the big picture as well, and talk about the interactions of these various cases. There's also sort of the process angle here, and the idea of division resources. You obviously were running the division for a while. What do you think? I mean, is the DOJ basically tapped out? I mean, are these tech cases really taking a lot of resources, enforcement capabilities away from other actions that the DOJ could be bringing? How do you see those issues with your sort of former enforcer hat on? And make sure you come off mute.
He's muted.
There's no question that if you take on a case of this magnitude, you're going to be using resources that might be put to some other use. That doesn't make it a good thing or a bad thing. It's just a fact. And whether DOJ is working at capacity and really strapped, I don't know. I just don't know. Let me make a couple of comments on these so-called big picture issues that we've been talking about. I agree with, I think, probably everything that Rebecca said today, but there's one little gloss on there, a footnote I want to put on. There's an aspect of the complaint that I think does reflect a kind of new Brandeisian influence, and that is in the market definition area, which we all think is probably less important than is commonly thought, but in that area, the complaint seems clearly to be emphasizing the so-called brown shoe criteria, the qualitative factors that the court several decades ago thought were the way you should think about approving a market. And I think they're going to have a difficult time selling to any court the idea that that's enough to prove a market. The complaint does allege in paragraph 171 that competition from other phones is not sufficient to prevent Apple from exercising monopoly power. So it may be, that may be signaling that the government's prepared to meet the requirements of the horizontal, the hypothetical monopoly test, the more economically rigorous test, even if it doesn't have pricing data. In other words, to use the brown shoe criteria as evidence, but to use the hypothetical monopoly test as a conceptual framework, which I think would be the right way to end up. But if they just rely on brown shoe without more, I think they're going to have a problem. The discussion, the comments that a couple of people made about the importance of not interfering with or reducing incentives for innovation by Apple clearly raise a legitimate concern that antitrust enforcement has to deal with. But it also reminds me of the rhetoric at the time of the Microsoft case. Oh my God, Microsoft's a national champion. How can you do this? I mean, we're not going to say to the law should allow Apple and Microsoft, for example, to have their employees ignore the speeding limits because they might get to work more rapidly and that will facilitate their job. We obviously want to bring them within the legal process. And more important, that argument overlooks the fact that the antitrust laws aren't concerned just with Apple's ability to innovate, but also with the implications of its conduct for the incentives and opportunity for innovation by third parties. And that has to be taken into account. And I think my prediction is that the government will prove harm to competition from the conduct it has alleged, and that Apple will prove that at least some of it serves some legitimate purpose, which Microsoft failed to prove for the most part in that case. And then this case might well force the court to do something the courts have been trying for decades to avoid having to do, which is to resolve the question of what do you do when you have proven harm to competition and proven legitimate benefits from the harmful conduct. The Epic court and maybe the Microsoft court kind of said, well, if there's a benefit, that's enough, end of inquiry. I think that's an irresponsible way to do it. Ad hoc balancing, I think we all agree, doesn't make much sense. The Epic Court said there's no metric for that. So the question is, are they going to try ad hoc balancing? Are they going to try to duck the question by finding a less restrictive alternative? Or will they use what might be thought of as a balancing algorithm, like the no economic sense test, which Rebecca has referred to, and which I'm a big supporter of, that would basically ask, okay, the conduct has good things and bad things. Would Microsoft have engaged in this conduct if it didn't have an anti-competitive payoff? Would it have reduced the value of apps on its platform if the only benefit were the benefits, for example, to security and privacy that it alleges? That may well wind up being the deciding question in this case.
Great. Well, I think we're going to have to leave it at that. I see we're just sort of at the hour here, and maybe conclude that I think we can all agree Apple would have been much happier with some of its employees getting speeding tickets than this major antitrust lawsuit. But thank you to all of our panelists for joining us. And I just want to thank also the folks who tuned in. Thank you for listening, and really enjoyed this edifying discussion on a very important case, which we're going to be talking about for a long time, I think, to come. So please do continue to follow ITIF. We're monitoring closely everything antitrust and tech. And again, thanks everybody. Have a good one. Take care.